some major decisions reached by the United States Supreme Court in the Fisher versus United States case, finding that the obstruction of official proceeding charge used by the Department of Justice to prosecute many of the January 6th insurrectionists did not apply and could not be charged with that type of conduct at issue on January 6th. I want to speak with Harry Litman from the Talking Feds YouTube channel about that, and will that have any impact on the two Trump charges? There's 4 total charges against Trump. 2 of them are obstruction of official proceeding under 18 U.S.C. 1512 sub C sub 2, and how this ruling impacts that. But there's even the bigger ruling, and I think the court kind of dropped them on the same day. They're very sneaky with how they drop these. I think they may have known that Fisher may be the one that got the big headline, and then let their decision overruling 40 plus years of precedent in the Chevron case with deference to administrative agencies try to, I guess, float under the radar in the Friday, dump type of thing. It's always so odd to me when the Supreme Court does that, Harry. Like, it's just such a throwback where people are like, dump your bad news or your controversial ones on a Friday. The news isn't going to pick it up as much, as though we're not living in kind of a different technological age, but so be it. Let's break that down. I want to remind everybody, subscribe to Harry Litman's YouTube channel one more time. It's called the Talking Feds YouTube channel. Harry, let's talk about Fisher. Let's talk about the companion cases as well that resulted in overturning Chevron. How big of a deal is it?
The biggest deal that this court has ever done, and this court has done some really big deals, depending on how you measure it. So an impact, obviously Dobbs is a big deal, and everybody understands that right away. But Chevron, their decision today, which basically represents a huge power grab for the court, taking it away from Congress. Congress has been saying for years, look, some of these technical questions, clean water, public health, all kinds of things involving pollution and the like. We need the administrative expertise of agencies. We depend on that. And the court says, no, you don't, not any longer. The Chevron principle, when it was enacted some 40 years ago, conservatives loved, but now it's become on the hit list of the more recent conservatives, and they hit it and took it down. And it's not going to have the same oomph in the public eye, as you say. It's more arcane and nerdy, but I'm telling you, like, law students and professors are picking themselves up off the floor, and textbook publishers are holding a bonfire for their old books because they're going to need completely new ones. This is Justice Kagan writes a really strong dissent. She is by far the administrative law expert on the court, and she says, you are stripping away the expertise of for so many important questions that affect so many people's lives. And who's left to decide, says the court? It's the court, it's judges. So here's a good example. Matthew Kaczmarek, remember him? He's the one who says the FDA actually made a mistake when it eased the restrictions on mifepristone. FDA had all this expertise, and they were right to ease the restrictions. Mifepristone had been shown to be safe. Now, no deferring to that. Just the district court decides for themselves, and that happens in DC and around the country dozens of times a month on the most important. We are now in the administrative age with all these technological and media, all these things that require expertise. They've been done at Congress's behest and desire. There are elected representatives for all these years, and now it's gonna go to judges. So that's just, it strikes me as a really dubious one, but let me tell you, in terms of enormous impact, this is as big as any case in years. The overruling of Chevron is friggin' nuts. Okay, Fisher, you're right. We'll stay a little nerdy here, 1512 C2, but it's pretty straightforward. The basic idea is Fisher's a guy who said, look, yeah, I was there along for the ride, and okay, I roughed up a cop or two, and he got charged for that. But he wasn't trying to impair the proceeding. He said, I didn't even, and especially, I wasn't trying to destroy any evidence. And what the court said is 15C1, the one right before it, is about destruction of evidence and documents, and 15C2, even though it's in very broad phrasing, needs the same limitation. Really interesting asterisk here. Justice Barrett, joined by Kagan and Sotomayor, dissent on a plain meaning reading, and that's going to be, people are going to be writing after the term for sure. Is Barrett staking out space a little to the even left of Roberts and Kavanaugh? But let's cut to the chase, which would be Donald Trump, because he's charged under this law. And he'll certainly argue now, you got it. Two of the four charges are under 1512C2. But as I read the opinion, they'll still hold, and this will go to Judge Chutkan first in the DC Circuit, because it's true he didn't destroy or mutilate evidence or records, but guess what he did do? He impeded it. And what records? These certificates, the very ones that Pence was opening the envelope to announce. He clearly, the whole soul of the scheme was to try to impede the effectiveness of those papers, substitute the phony baloney papers. So even under the court's reading that you really need to be trying to get at evidence or documents, etc., I think it cleanly applies to what Trump is charged with anyway. And while he'll make the motion, I don't think it'll succeed, and the obstruction charges will still stay against him.
Look, when we're talking about that Chevron decision, if people have a little bit of confusion, I think maybe a way to think about it is this, that when Congress passes law, either an enabling statute that may be, creating an agency or delegating certain authority to an agency, whether it's the EPA or the SEC or the FTC, look, Congress can barely agree on anything. So when it finally does act, it usually gives a broad strokes directive. We need you to help out climate. Here are the goals. Here are the aspirations. Here's how you, if it's the SEC or the FTC, here's how we want you generally to go after bad actors. If it's, agencies that deal with AI, here's how we need to kind of protect intellectual property in the age of artificial intelligence, or here's how we need to make sure that AI isn't, allowing criminality to, so whatever it is. So then the agencies are made up of experts who look at the broad directive, and then they apply their expertise, and then they regulate in that area. Depending on the types of administrations, that can mean more regulation or less regulation. So it's not like they're just these unelected kind of people doing these things. Usually the president's elected and sets the tone of how these executive agencies are going to act. And it's also not like during the Chevron era, there was no role for federal courts. If an agency acted arbitrarily and capriciously and outside the bounds, a federal court could jump in and stop them. But what makes the Chevron decision, or this decision overturning Chevron, is it's basically saying, unless Congress gave you the specific instruction of what to do, you don't even have the right, agency, to come up with your own interpretation that we're going to give you deference for. See you later. It's up to us now, the courts, that are going to decide what it is that you're entitled to do, unless it's very clear, and Congress is just never going to act like that. So for all purposes, right, it really just guts the ability of agencies to function. And in an increasingly complex world, we need things to function and carry out directives. And so you may, and I'll throw it back to you, but people go, well, why would they do that? Well, rich people don't like being regulated. And so wealthy people do not want regulators to say, don't do that or don't do this. And now they can just go to the court, get Judge Kaczmarek or whoever, and say, The Congress never said that. They are interpreting it. And the judge goes, yep, sorry, we don't have to give you any deference anymore. See you later. So that's what's at play here. I'll let you have the close, but that's how I think about it.
No, I think you're really bingo. You're on the money. And understand, these are the ultimate. Congress sets these parameters, but 53 parts per billion or 90 parts per billion, spectrum this wide, spectrum that wide. You need to make those decisions, a lot of technical expertise. And the court is now saying that's interpreting statute, but they are now going to have to make these decisions and some of them are going to be totally wackadoodle, right? And so it is part of, I think, of what's become. It wasn't in the previous generation, but it's got to do with the real hostility of the court toward this. This is a strain of conservative thought, unelected, federal bureaucrats, and that whole specter that I think is congenial to Trump, of people in Washington somehow affecting our lives. But they're affecting our lives with, really technical knowledge, and now that knowledge is just going to be set to the side somehow. So, even if you believe that the deep state, officious bureaucrats, et cetera, why would you want to change this? It's one thing to force Congress. Okay, Congress, you say 53 parts per billion versus 58 and have evidence, but courts, Matt Kaczmarek, man, oh man, it's it's part of a really big theme of this term, which is the court getting more power for itself, really self-aggrandizing, and that's a bottom line of a lot of these decisions.
Taking the power away from we the people and handing it over also to billionaires and decamillionaires who we then find out are paying for lavish vacations for people like Justice Clarence Thomas, who I guess will be taking those vacations soon.
You could link those problems together. It's true, but a revolution, a tsunami, fill in the blank, a really big decision.
Hit subscribe. Let's get to 3 million subscribers here, but more importantly, go check out Harry's YouTube channel at the Talking Feds YouTube channel. It's partnered with the MeidasTouch network. We want to get that channel 250,000 subscribers. Last time Harry was on, we got 5,000 new subscribers in a 24-hour period. I want to beat that right now. So let's try to do 10,000 new subscribers in a 24-hour period. Go to the Talking Feds YouTube channel right now. Subscribe. It's free. We need more voices like Harry out there on YouTube and elsewhere, getting out this pro-democracy message and facts and truth. Thank you, Harry.
Thank you. What a week. And I understand there was a debate as well. So quite the tsunami in the whole political legal sphere. See you later.
See you later. Have a great one.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.